Still on the issue of photographs, is there a conflict between the ownership of copyright and data protection? Well, let's look at it. Welcome to Education, our weekly legal podcast, where we break down legal issues, legal topics, legal concepts to your understanding without having to go to the law school. Okay, somebody sent me a message after the episode we had last week about photographs and all, asking whether the use of someone's photograph by the photographer does not amount to the breach of data privacy and all. Now, let's look at it this way. You remember that last week I made mention to you that when it comes to photographs, the authorship or the copyright resides in the photographer. And unless that photographer has consented by agreement to transfer the ownership to you as the photography, that is the model, you do not have copyright on it, and you cannot use that photograph anyhow you want, except as permitted by the photographer. We went ahead to also say, even by case laws and all, that a photographer can go ahead to use that image or that photograph that he has taken for even commercial purposes. He can even sell it and all. By the Copyright Act, is permitted under the law to do that. But then somebody called my attention, or somebody raised a question to say that will that not be a breach of Data Protection Act? And we have to look at it together, and I also agree with that. Now, by the Constitution of Nigeria, every individual has a fundamental right to privacy. All right, they have that fundamental right to privacy. Now, by Data Protection Act, from Section 24, if you read Section 24, Section 25, and then Section 26, it suggests that a data subject, in this case the person in the image, has the right to his privacy, has the right to determine how his data is used or is processed. And by that act, it says that except for what the data subject intends that data to be used for, you as the data processor, in this case the photographer, will need to seek the consent of the data subject to now use it in any other way. Now, the law now places a very great responsibility on you as a data processor, that is the photographer, to prove that this person has consented to the use to which you are putting that photograph. What it means is, unless I have agreed that you can go ahead and sell my data, that is my photograph, unless I have consented for you to use my data on the billboard and all of that, you will not be able to use it that way. And you have to also show, if any issue arises, you have to show that I have consented to that. Now, the law specifically now says that silence does not amount to consent. That is, the fact that I'm silent about the use to which you can put it does not mean that I have consented to it. That means if issue arise, you as a photographer has to show that I have consented to the use to which you want to put it. Now, what's the gist in all of this, or what's the way out in all of this? Both as a data processor, especially for you as a data processor, what's the way out for you as a photographer to protect yourself or your business? The best thing for you to do to protect yourself is that you have an agreement with anyone you are before that photo shoot, before that, going out to take pictures at the weddings and all. Always have a contract. By that contract, you protect yourself. You determine how far you can go with the use of those data and all. Don't take this for granted. You may have to pay so much for it. Thank you for joining with us on Education today. It's been a wonderful time. Make sure you subscribe, you like, you share to other people, and join with us again next time.